Good morning, everybody, and welcome to the fourth session of the 2020 end of the year webinars of the CSR blog. I give the floor to my colleague Costantino Grasso for the presentation of the today session. Thank you very much.
Dear Luca, thank you very much. Welcome, everybody. It's an honor to give this introduction today. So I would also like to give a big thank you to you all and to Josh that I have the honor to present today. So Josh Bornstein is the head of employment and industrial relations at Maurice Blackburn Lawyers, which is the Australia's leading social justice law firm. Josh has over 20 years of experience as a lawyer working in the area of employees protection. He has represented many trade unions as well as the Australian Council of Trade Unions. He also advises managerial and professional employees throughout Australia. He has represented many women who have endured sexual harassment, including recent cases involving Australian MP and former Judge Dyson Heydon. Josh is also a board member of the think tank Australia Institute and an advisory board member of the Center for Future Work. So Josh today will speak about corporate responsible behaviors that attempt to limit employees' free speech. It's not easy to introduce this topic to you. I will try to do my best. So basically what I think is that thanks to recent technological advancements, cultural changes, and in particular the influence of social media platforms, employees have many more opportunities today to broadcast their opinions. Comments that would once have been uttered in a pub now are disseminated around the world with a single click. So even if it's illegal in most European countries to fire people for their political beliefs, this is not a very strong rule and for sure not globally. Most Americans enjoy no protection of their political beliefs. In 2004, a woman in Alabama was legally fired from a housing isolation company for having a John Kerry bumper sticker on her car. And in December, a man playing Father Christmas at a mall in Georgia was replaced after photos emerged online of him wearing a pro-President Trump baseball cap while on duty, even if he claimed that it was just a joke. So basically, employers say that they need to restrict the expression of certain views in order to create inclusive workplaces. And the human resources and employment lawyers working for the firm, so that's not Josh, defended the dismissals as the only way to protect employees from hostility of the company and the company from litigation and bad press. The problem is that firms appear increasingly concerned about what their employees say and write outside the office in their merely private sphere. So corporations are increasingly exerting the influence and abusing what we know is an incredible level of imbalance of power between them and the employees to silence the latter when they express opinions that are not in line with corporate interests. For instance, Amazon employees recently claimed that they've been threatened with dismissal for criticizing the firm's climate policies. Google has been accused of trying to silence dissenting voices, including those that criticized the firm's response to sexual harassment and its secretive work in China relating to their use of artificial intelligence for detecting anti-ruling party behaviors. In the absence of adequate regulations and corporate governance rules and ethical boundaries aimed at protecting employees' freedom of expression, firms are moving to spell out their expectation in uncontrolled codes of conduct and social media policies. The level varies. Intel has just asking, for example, employees to use common sense, whereas General Motors have a 12-page social media policies that expressly says your online communication will not be excused merely because they occurred outside of work hours or off GM premises. Such burning issues will be discussed today by Josh Bornstein. Thank you, Josh, for being here. I immediately give you the floor. Thank you very much.
Thank you very much, Costantino. That was a formidable introduction. And I'd like to start with some acknowledgements before I dive into this complex topic. The first thing I'd like to do is acknowledge the traditional owners of the land on which I stand at the moment, or which I am at the moment, and pay my respects to their elders past and present, and for everybody's information, I'm in Melbourne, Australia, and the traditional owners of the land in Melbourne are the Wurundjeri people of the Kulin Nation. And I'd also like to acknowledge we're in an unusual time at the moment with the pandemic and the unusual position in Melbourne, which I mentioned before we started tonight, which is that Melbourne had a outbreak several months ago of COVID-19. The number of cases grew to about 700 a day, and we went into a very strong lockdown. And we've just come out of that lockdown after 4 months with no cases. For the last 24 days, no cases. So I acknowledge the difficulties people are facing all around the world, particularly in Europe and the United States, in trying to address the problem. But Melbourne is a very good example about what you can do if you go hard to try and face the current challenge. Now, let me start what I have to say by telling you a story about a famous Australian sports player whose case came to public attention not that long ago. His name is Israel Folau, F-O-L-A-U, and he's a professional rugby player, a champion rugby player in Australia. He's also a fundamentalist Christian. He's had a highly decorated career, playing for the Australian Rugby League and other codes. And throughout his career, it's been well known that he was a devout Christian, and he's frequently spoken of his devotion and his involvement with his family in their church. In April 2019, he took to Facebook and posted the following words, which condemned, and I quote, drunks, homosexuals, adulterers, liars, fornicators, thieves, atheists, and idolaters to hell unless they repented. As you can imagine, Costantino talked about the atmosphere we now live in, where any view we can post on social media can go viral. Well, this was one of those cases. There was enormous controversy in the community, a lot of condemnation of particularly his hostility towards the gay community in Australia. And as a result, the company, the Australian Rugby League, which is a monopoly in sport, professional rugby, came under a lot of pressure from the community and from sponsors and the like. And it investigated whether Folau had breached its company policies and failed to adhere to its values. The policies stated that the Australian Rugby League is a fair, safe and inclusive environment for all, and employees must use social media appropriately. Now, like all employees these days and all employees of the Australian Rugby League, Folau had signed an employment contract that said, I agree to comply with the company's policies and values. Another episode of what we call the culture wars erupted with the Folau situation. And I found myself in a very interesting position. I come from the more progressive side of Australian politics. I acted for trade unions and employees and support human rights and generally favour that side of politics. And for years, we had watched as a number of progressive individuals who had posted or said something controversial about war crimes or abortion laws was attacked and sometimes sacked for their politically progressive but provocative comments. And many people like me had condemned these sackings. But on this occasion, many progressives, in fact, condemned Folau for his homophobia, but in doing so, they emphasised that he had breached his employment contract. Employment contracts, if you know anything about employment contracts in most of our systems, are very asymmetrical documents where there is a great imbalance of power between employer and employee. And it's not usually that the situation that people who are interested in human rights and progressive values champion the employment contract. Often it's regarded as an oppressive instrument. But that was the situation. On the other hand, many right-wing commentators and politicians all of a sudden discovered a love of human rights and said, in fact, Israel Folau's human rights were being breached. He has a right to express his religious views. He wasn't at work. He was posting his views on Facebook. And again, this was a reversal. Most of the time in the Australian political context, these right-wing commentators and politicians are the ones that call for the sacking of employees who express left-wing views that are controversial. So there was a complete, I suppose, reversal of the positions that many people took. And I found myself being invoked in support by people on the right of Australian politics. And as I say, I'm not one of them. Ultimately, Folau was sacked from his career at Australian Rugby League, and he hired some lawyers and mounted a challenge in our legal system relying on anti-discrimination laws which protect the expression of religious opinion. In fact, the law says you cannot be sacked because of your religion. Now, that law has very rarely been tested. No one actually knows what it means because there are no authoritative decisions about what that means. Did the law protect a particular type of religion, whether you're Jewish, Muslim or Christian or some other religious, Buddhist or whatever the case may be, or did it extend to expressions of religious sentiments? Well, we still don't know because ultimately the case was settled, and it's assumed it was settled by the Australian Rugby League paying Israel Folau a large sum of money. He was on a very lucrative contract because he was, one of the great stars of Australian Rugby League. In any event, the case settled, but that still left Folau in a difficult position. His religious views hadn't changed, and the Australian Rugby League is in fact a monopoly employer in his industry, and most employment contracts now contain very similar requirements. So ultimately, like a number of dissidents who've been sacked in this way in recent years in Australia, he was forced offshore to go and find work overseas, and he's currently playing rugby in Europe. So the consequences for him were absolutely profound. And indeed, he was probably a lot more fortunate than many other people who are sacked in similar situations. Many of people who are sacked in such similar situations are traumatised for years afterwards. But he, I think, has not suffered in that way so much. Nevertheless, he now doesn't live in Australia and works overseas. Now that brings me to discuss the whole question of the prevalence of company values and codes of conduct, which Costantino mentioned. In Australia, the employment contract has been revived. When 50 years ago, Australia had a much more unionised labour market with strong union presence and protection. The employment contract was moderated and wasn't so dominant, but the Australian labour market has been de-unionised. Only 9.5% of employees in the private sector are members of a union, which is an incredible collapse over the last 30 years. Very fast collapse, one of the fastest collapses of unionisation in the OECD. So the employment contract now rules the labour market once more. And I see these contracts every week from all sorts of organisations. And the remarkable thing about employment contracts is that they are template documents. They are not negotiated. They are prepared by lawyers for the corporation, and then they are signed by the employees. And if you're in a workplace of 100 people, they'll be identical. If you're in a workplace of 5,000 people, they'll be identical as well. All of these contracts follow a fashion. And the fashion now is that each employment contract will say, I, the employee, agree to abide by your policies and your code of conduct. When the employee signs that document, the employee doesn't even know what the policies or code of conduct say, because they haven't commenced work and they don't get that sort of information usually until they've started work. The contract will also say the employer can unilaterally change any of those documents as and when it sees fit. So there's another little twist to this trap, because it's a spider web that is in fact being cast. And that is, if you read the fine print, the contract will say, you, the employee, are bound by the company values and the code of conduct, but we, the employer, are not. And I'll explain to you why that trick is in there. The company values that are promulgated in these documents are very, very similar. If you look at many of the major corporations across the world, their corporate values are in very similar language. Very popular one is integrity, transparency, inclusiveness, honesty, respect. These are the attributes or values that the company claims are its values. So, of course, one of the risks that follows to a corporation, if it promises to comply with its own values, and in an enforceable document, is if it harms an employee by failing to act with integrity, it can be sued. So the reason the contracts give it an escape clause saying these values apply to you but not the firm is because the corporation wants to ensure that it's not held liable for breaches of its own values. So the asymmetry is quite stark. In addition, again, as Costantino mentioned very astutely, social media policies are extremely fashionable and are everywhere. And they essentially provide the same requirement, and that is employees must not post anything on social media that's not inappropriate. What does that mean? Well, you can't know. You cannot know when you sign up to that policy. You cannot know what that word means or that set of words mean. It is part of the, I think, perverse language of corporations that we are now subject to. The other rather fascinating element of the contract and the policies and the values is they apply to you not only at work, but outside work. So you are being required to act with integrity, transparency, respect, inclusiveness, and so on, 24/7. Just reflect on that for one moment. At work, always respectful, always transparent, always with integrity. Outside work, always with respect, integrity, and so on. Now, I like to think I'm a good person, but do I always behave perfectly and so that my behaviour complies with a stipulation in a contract like that? There is absolutely no way. Sometimes I am grumpy, sometimes I swear, sometimes I have an exchange with people that's not as respectful as it should be. Can you imagine? In fact, I'll start again. I was going to say, I'm not religious, but I think Jesus, who was a very good man by all accounts, was very fortunate to be a self-employed carpenter before Facebook was invented, because Jesus could not comply with a modern day employment contract. There is an insidious dimension to this, of course. By entrenching a set of requirements that no employee can always comply with, the employer has maximum power and discretion to dispense with employees when it sees fit. And it can invoke those parts of the contract at any time against a range of employees, but it only does so in certain situations when it sees fit. This is analogous to a totalitarian regime, and which is why, for example, academics, including an American academic philosopher, Elizabeth Anderson, has written a book called Private Government, basically saying, why do we as employees submit to repressive and oppressive sanctions and standards and control when we go to work, when we would not accept the same from any government? In fact, the attempt to control workers oppressively has a long history. And I'm going to jump back almost 100 years exactly to talk about what was going on in Hollywood at that time, because it has a strong resemblance to the current situation. In 1921, an actor by the name of Roscoe Arbuckle, also known as Fatty Arbuckle, was the most famous Hollywood actor in the days of silent American film. And he was the first Hollywood star to sign a multi-million-dollar contract with Paramount Studios. He was at the top of his game, the talk of the town, and adored by millions. That all came crashing down after a party that he attended. After that party, he was charged with the rape and murder of an actress by the name of Virginia Rapp. He then endured 3 trials. The first 2 trials, a verdict couldn't be reached. This was over a period of years. And in the 3rd trial, he was finally acquitted. And a jury issued an extraordinary statement condemning the gross injustice that he had faced over the preceding years. And there has since been a lot of research to support the idea that he in fact, was not guilty of that crime. But his career was finished as a Hollywood actor. In response to that scandal and the loss of this asset that the studio had, Hollywood studios then began to require in all contracts with film stars, writers, directors, a morals clause. And I'll read to you a typical morals clause that became a stock standard part of the employment contract in Hollywood. The actor shall conduct himself with due regard to the public conventions and morals. The actor shall not, either while rendering such services to the producer or in his private life, commit an offence involving moral turpitude. The actor shall not do or commit any act or thing that will tend to degrade him in society or bring him into public hatred, public disrepute, contempt, or that will tend to shock, insult, or offend the community or public morals or decency, or prejudice the producer of the motion picture, theatrical, or radio industry in general. So all Hollywood talent then were forced to sign contracts with morality clauses. Now, let me tell you how those clauses then operated. Rock Hudson was, some years later, again, like Roscoe Fatty Arbuckle, a famous institution in Hollywood, at the height of the industry. He was also homosexual. And at any time, he could have been outed. And if he was outed for his sexuality, he would be in breach of the morality clause. And like other gay actors, they were fearful of the consequences. So part of managing that situation and managing his employment contract involved a marriage which was a fake marriage in order to address that situation. In the 50s, when anti-communist hysteria swept the United States, there were very famous hearings in the Senate into Hollywood actors and script writers and whether they had affiliations or connections or sympathies with communists or communism. And they were very publicly humiliated and hauled before these McCarthyist hearings. And 10 of the actors and script writers protested and were dissidents during this period, hysterical period of persecution. They refused to answer questions and to testify about their friends and colleagues' alleged sympathies. As a result, the Hollywood studios sacked them for breaching the morality clauses in their contracts. They each challenged the sackings under different state legal systems in America, and all of the legal challenges failed. They were then black-banned from earning a living in Hollywood in the ensuing decades. That's not the end of the story about morality clauses, because morality clauses still survive today, but only generally for a very small subset of the working population. For example, famous ambassadorial sports stars who are ambassadors for Nike or for Adidas or other companies have these clauses. And even I noticed recently some publishers have been introducing them for famous writers. But the effect of morality clauses from 1921 are not all that different to what all employees are now signing when they sign an employment contract, which requires them to abide by values that must uphold the highest moral standards at all times. And as a result, if you think of it that way, we are all now brand ambassadors. Once upon a time, if you were Rock Hudson, you might be earning millions of dollars with a morality clause, or if you're a brand ambassador for Gucci, you may be earning millions of dollars. But the employment contracts that everybody signs apply to minimum wage workers all the way up the chain. So, and the effect is to, as I say, transform an employee into a brand ambassador. Now I want to focus on this notion of company values, which we repeat and has become part of the common lexicon. I want to ask you first, which company says on its website about its values, integrity. We always strive to do the right thing. Our commitment to the truth is unwavering, both in action and in words. And the answer to my rhetorical question is Volkswagen. Now, as many of you may know, Volkswagen has in recent years been engulfed in major controversy for cheating climate emission targets, if you like, that basically the company set up its cars with systems that were designed to mislead regulators about the amount of emissions that the cars were emitting. And as a result, has had to pay billions of dollars in fines and is facing multiple class actions. Yet we continue, notwithstanding the many scandals that engulf companies, to talk about company values. My thesis is that company values, the expression is an oxymoron. It doesn't make any sense. Values belong to people. Human beings are capable of holding values or violating values. Corporations are not people. Corporations are entities that are artificially created for the private sector to allow people to come together to pool money to make more money. A corporation is not a human being. It's not capable of holding a value. Its sole purpose is to make a profit. If we were able to create human beings whose sole purpose was to make a profit, there would be a word for that: psychopath. So the expression company values is ridiculous and totally misleading and an exercise in anthropomorphism, but it's very deliberately so. Why? Because it is designed to humanize the corporation, to make the corporation look something, to have an identity that it really truly doesn't belong to it, and to distract us from its true nature and conduct. And in that way, company values fit very neatly into, I think, a whole language that is perverse but pervasive at the same time, and which is also redolent when you look at CSR programs. And to discuss the link between CSR and company values, corporate social responsibility and company values, you've really got to look at the last 40 years of what I call the neoliberal project. And there are many ways and debates or ways to define the neoliberal project and debates about what it means. I think it can be viewed very simply as a project to redistribute income from workers to capital, from workers to shareholders, to maximise shareholder value. There aren't necessarily a coherent list of policies that neoliberalism embraces, but there are policies that have certainly operated in the last 40 years to redistribute income from employees to business. Deregulation, privatisation, poor regulation, buying politicians, buying political influence, taming regulators, destruction of the climate and the environment, the deunionisation of the labour market, and of course, the subversion of the tax system. These are the features of big business in particular over the last 40 years as part of the neoliberal project. Alongside that neoliberal project has been the development of immaculate company values and the development and promulgation of immaculate corporate social responsibility programs. We're living in an era that many have described as like the second Gilded Age, where inequality of income and wealth has increased, where large corporations have, particularly in the technology sphere, become incredibly powerful monopolies that flout their power against the laws of states. And at the same time, the language of corporations that seeks to fend off regulation, fend off political movements that seek to moderate, if you like, the abuses and excesses of this era. Corporations are using Orwellian language and initiatives. You will never see a corporate social responsibility program dedicated to improving tax collection or eliminating efforts to tackle company tax avoidance. You'll never see a corporate social responsibility program advocating proper regulation by new laws for the private sector or greater involvement of trade unions in the labour market. More recently, the language again has taken another Orwellian and perverse turn with the birth of stakeholder capitalism. Again, another attempt in the last 12 months to try and fend off regulation by the state. So when it comes to determining issues of morality that affect employees, and sometimes dealing with very difficult moral and legal issues. For example, Israel Folau, was his statement condemning homosexuals sufficiently harmful for the state to intervene and deal with it and change the law to stop that sort of vilification? Instead of the state acting to address these very difficult issues, political issues and moral issues, we increasingly allow and cede that right to the private sector at a time when, in my view, the private sector is completely out of control, not properly regulated, and engaging in extraordinary numbers of abuses in the financial services sector, where we've had an extraordinary catalogue of abuses in this country, many abuses in the labour market, environmental abuses, and climate change ravaging the planet. The last institution that I would vest power in to determine difficult moral questions is the private sector. A private sector, as I say, that's out of control. And just to be provocative to Costantino, because he likes it when I'm a little bit cheeky, I'm going to also argue tonight in Melbourne time, and I know it's not night time where Costantino is, that universities have now fallen into the same trap. Universities in Australia and other Western nations have become big businesses and have started to operate, even though they're not-for-profit entities, they are increasingly aping the mores of the private sector. You see now, particularly in Australia, and I think this is going on elsewhere, very highly paid managerial staff, vice-chancellors in Australia on $1.6 million salary, and then going down the pyramid, at the bottom of the pyramid are thousands and thousands of casual gig working academics. In the middle are very well-paid management, including brand managers. And as a result, academics are increasingly being sacked for expressing controversial views because they embarrass the brand. And the brand is particularly valuable in chasing what are called in Australia the rivers of gold, international students. This is a huge export industry in Australia, and as I understand, internationally. So any controversy which might affect the brand is highly perilous for an academic now. And I recently represented an academic who went on a television program to blow the whistle on the mistreatment of international students at a university in Western Australia. Within 2 days, there was a move to sack him from the Senate. We went to court to get an injunction to stop his removal from the university Senate, and we sued the university, and the university responded by issuing a counterclaim for $15 million in lost income from lost revenue from international students. The case was only resolved because the excessive punishment of my client resulted in an international campaign of academics and condemnation from all over the world. But this is now a feature of academic life because universities increasingly resemble a private sector corporation. So I just want to check the time. I've got a little bit more time, but Costantino, let me know if you need me to wind up. 1 minute, okay. What are the implications of all of this? Well, the implications are profound. When we sign an employment contract, not only become brand ambassadors without any of the remuneration that true brand ambassadors attract, we also give up our citizenship, our rights to dissent, to engage in political activity, to engage in commentary in the public square, which is now the social media. We're required by our contracts not to act inappropriately, whatever that word means, either at work or outside work. We can never be sure what inappropriately means. The difference really is not in the content of the social media post. The difference is whether the social media post is highlighted and goes viral by an opponent of the point of view expressed. You can publish a social media post as an employee and get no reaction. A year later, you can post the same social media post and lose your career because it attracts the ire of, for example, the Murdoch press around the world. So the implications are anti-democratic and diminish our citizenship, diminish our ability to participate in democracy. We should not, in exchange for the right to work, give up these foundational rights to our citizenship and our rights to participate in democracy. And that's why I'm so passionate about this subject. And in fact, I'm trying to write a book about it. But the book will have to wait another day. Thank you very much.
Thank you, Josh. Thank you so much. It was a brilliant presentation, and we look forward to reading your book, of course. I love when you are provocative, and also I think that you cover so many interesting things, especially when you spoke about, for example, corporation values. And I think that there is a lot of corporate hypocrisy around. And I was with my student, some of them are here. We were looking, for example, at the code of conduct of J&J, and they call it a credo, like a faith to the protection of patients. And we know what they've done: corruption and abstentions in a talk and all these things. You know what credo is that? So I mean, yeah, there is a lot of corporate hypocrisy, and especially in CSR. So we have to fight against this. I absolutely, in line with you. And it's very scary what you said about the academic world, because indeed in the Anglo-Saxon world, especially, universities are more and more corporations, and there is this discrepancy between the management and academics, and this is a way of managing power. This is clear, and I'm worried because as an academics, we always dream to change the world, and if you want to change the world, of course, freedom of expression is fundamental, is crucial element for creating a thriving teaching and research environment. And as academics, we should be critics. We should be skeptical. This is our moral duty. And how we can do that if they start, in a way, thwarting this. So I can just tell you something that you can further inquiry, maybe in the book, because there is an instrument that potentially, that is very good actually, but is a tool that can be used as an instrument, and is the ethical approval for our researchers. Now we have to submit a technical this ethical approval, and this sacrosanct is very important when we do intrusive or pervasive investigations like interviews, and this is very important. This is very important that. But technically, we have to submit it even if we do desk research. And when you wonder why, is that just because the thing that you would like to investigate on just purely qualitative analysis on other books, on other things that have already been published, can be not in the interest of the corporation, of the university. So this can be, if unrestricted and unregulated, used to direct, to limit academics in their research. So this is, I think, something that we have to be very aware of. I don't think that there are instances of using it right now that I know, but yes, is a potential issue. So thank you for highlighting this. So that was one of my questions. So I don't have any more this question for you, but I have another question. The question is that in such a scenario that you have brilliantly depicted, are you aware of any form of pressure or undue influence that corporations are exerting on the political process to keep the situation unregulated or weakly regulated like this, besides the general neoliberalist approach? But do you think that they're trying to avoid this regulation? Are they lobbying to avoid this kind of mandatory regulation that we should have to protect employees' freedom of expression? Are you aware of something happening like that or not?
Oh, the issue of the gaming of the political system by corporations and shaping public policy to avoid proper regulation is the subject of many books and many papers. Dark money, and I've just, it's about 10 feet away from me, and the author is a New Yorker journalist, Mayer, M-A-Y-E-R. Is a book about the epidemic in the US of corporations buying political influence and lobbying, campaigning, successfully knocking off politicians who propose to legislate in ways they don't like. This is, in fact, a reversion to the Gilded Age in the early 1900s, when then US President Teddy Roosevelt had to face up to what were called the robber barons, big monopolies that were mistreating workers, were crushing competitors, and which operated in steel and in other industries. And those companies effectively bought off politicians. And Roosevelt was aware, he was a Republican, unimaginable now that a Republican would be leading the charge to regulate and tame corporations, but that was Teddy Roosevelt's mission. And in order to overcome not only opposition from the Democrats, but opposition from his Republican colleagues, he partnered with investigative journalists to ensure that the worst abuses were published and became scandals that he could then exploit to drive regulation. Nowadays, corporations have and continue to successfully lobby to prevent proper regulation, which we see environmentally, we see in the continuing abuses of the finance sector, and we see the ongoing debate about how to tame the monopolies of the big technology companies, the Amazons, the Facebooks, the Googles, who now exert extraordinary power over states, individual states, but also over our lives as well. And even in Europe, which is leading the charge to regulate, they, in recent days, I've seen reports from the European Commission saying we still haven't been able to properly regulate these massive corporations. So I think the problem is getting worse rather than getting better after 40 years of neoliberalism.
Thank you very much, Josh. I totally agree with you. And yes, Dark Money is a fantastic book. Just another one has arrived on my desk. So it's not an advertisement, but this is a very good book. It's Captured. This has been written by Senator Sheldon, US Senator right now. And he's basically saying that the US legislature is captured by corporations. Yes. And so it's a big issue, and we have to try to discuss it. And in Europe, I think we are still a bit safeguarded because of the transnational, supranational level of the institutions that we have in EU. And I'm a bit worried because of Brexit now for the UK, because of course the UK won't be protected anymore by this supranational check. And they also would like to, try to go out in a way or limit the Strasbourg court, so the human right supranational check on the politics, especially on immigration. So I think that we enjoy this supranational check. This is fundamental for us. And unfortunately, there are this pressure to get rid of it.
Yes.
Yeah.
We had a very good example, if I can give you an example in Australia of how corporations manage the political process. Years ago, there was a proposal to introduce laws to impact companies like 7-Eleven, which you have 7-Eleven in the UK, I imagine. No, you don't? Okay. It's
in the United States, not
in the United States.
Yeah.
We have 7-Eleven, many 7-Elevens all over the country. They operate as a franchise network. Franchises networks are notoriously problematic because the franchisor has contracts which strongly advantage the franchisor and disadvantage the franchisee. And there was an attempt to change the law to balance the ledger better. The franchisors lobbied very strongly, the Conservative government, and the law didn't proceed. Within 18 months of this, a great scandal erupted because it transpired that most of the 7-Eleven stores owned by the franchisees were paying staff as little as $5 an hour, which is £2 an hour or something like that. In euros, I can't remember the exchange rate, but less than half the minimum wage. There was gross exploitation going on. Many workers were migrants, vulnerable migrants. And when the facts were assessed, it became clear that the only way the franchisees could make money with the contract they had with the franchisor is to not pay the worker properly. So the effect of not properly regulating was pushed down the line, and the ultimate victim were thousands of migrant workers who were underpaid hundreds of millions of dollars. So that's a very small example in a way, but a very good example of the power of the private sector to shape the system.
Thank you very much. Let me give now the floor to Luca for his questions.
Thank you, Costa. Josh, let me thank you for this inspiring presentation. It was really interesting, and inspired me a lot. I have many remarks and questions, but I'll try to limit to a couple of questions to give the floor to the participants. So the first question concerns the company values. You developed you made a classical CSR critical to the impossibility of companies to have values, other values than making profits to shareholders, for shareholders. But what happens when the regulator recognizes these values? And I'm thinking about the French 2019 law. It's called the Loi Pacte. I don't know if you know this law. But basically it's a law that allows business companies to establish other missions than making the interest of shareholders. So companies, and big French companies did, such Danone, for instance, or Michelin, they are already entreprises à mission. It means that they establish in their own code that they have a social and environmental mission. And this mechanism basically shelter officers from shareholders' actions. So officers are more free than they were before to have and to aim this social and environmental mission of the company. So they don't have to. They are not only accountable for the common interests, so for the shareholder values, but also, they at the same time they are free to aim this social and environmental mission. So I would love to have your opinion on this rule and this idea of mission business or entreprise à mission. And the second question concerns the employment contracts. And I wonder if there are more protective standards of employees' freedom of expression at the international level. And I think about, ILO conventions or global framework agreements, or if there is any discussion about this topic at the international level. And if so, if there is any case that try to challenge employment contracts rules using these international regulations.
Thank you for both fascinating questions. I'm fascinated by the French law or the change to the code that you mentioned. It's unclear to me whether this is institutionalizing CSR programs or it's a law that transforms the nature of a corporation.
Both.
Okay, that's very interesting. It's very interesting. And I suppose the question I have, one way of answering the question is to ask you the question, has it changed the fundamental nature of French private sector capitalism? Are the companies that are invoking this new mission paying taxes properly? Are they destroying the environment? Are they mistreating the labour force? France, in some ways, has more regulation than many other Western countries at the moment. So it may be in a different category to Australia, the UK, America and other countries, but I'm very skeptical about CSR programs, but I'm very supportive of proper regulation that moderates the excesses of the private sector. I'm an advocate of mixed economy, of having a private sector but properly regulated. And without knowing more of the detail, it's difficult to know, but it does sound interesting if it in fact tries to alter the nature of the corporation and whether that is having the desired effect.
I mean, if you can maybe give some answers to your question. First of all, I mean, this law has been thought and implemented thanks to scholars working on CSR and working on the regulation of CSR. And so, I mean, this is the intellectual framework where this law has been adopted. And the first, I mean, I think that it's too early to appreciate the effects of this law. But what I can say is that the first companies that have been transformed in mission companies were the leading French companies on CSR.
Yeah. Okay.
So you know. It's kind of natural evolution from voluntary CSR to mandatory or regulated CSR. But I think it's still early to
say
the effect. But anyway, I will send in the chat some links on this law. So that you can have access to more information about it.
Thank you. Now, to go to your second question about employment contracts and whether the repressive dimensions in terms of politics and political expression can be moderated by ILO conventions and other laws, yes, the answer is yes. There are laws across many countries, some laws in states of the US, certainly in Europe and in Australia, which are geared to protecting political expression. And in fact, in some of the cases where I've represented employees in these situations, even academics who've expressed, for example, anti-war sentiment about military atrocities, and who was a journalist, not an academic, and who was sacked after a controversy about that. We went to court arguing that the sacking was illegal because our statute provided you can't sack someone for expressing political opinion. There are many problems with these protections. One is if you have a big fight with a big corporation, a case like that could cost $500,000. And when you're a sacked journalist or sacked ordinary worker, you can't afford that case. We ran that case that I mentioned about the journalist sacked over anti-war comments he made on Twitter for free. His name was Scott McIntyre. He was a journalist at a state-owned corporation and was sacked very unceremoniously for these comments. Because we acted for free, we were able to ultimately get a settlement, but that was after $500,000 of pro bono legal work by the best QCs I could find, fiercely fought for quite some time. So that protection is out of the reach of 98% of the workforce. Secondly, the protection is very limited for various reasons that relate to the legal environment in Australia and I think the conservatism, at least of some judges. What is a political opinion is very tightly confined. So there are some laws that we can invoke which seek to moderate the excesses of the employment contract, but at the moment we're fighting a losing battle, and it's made all the more difficult, I think, by the deunionisation of the labour market.
Thank you. Thank you very much.
So thank you very much, Josh. Let me say thank you and from all of us, because now we will go through the open question and answer time. So I will stop the recording right now, and the recording of this brilliant presentation will be available on the Corporate Social Responsibility blog. So thank you very much, and let's go on with the question and answer time.
Thank you.